even though he was a partner and should be liable?
Well, the statute of limitations problems in the client now going after Dahowski, I can see that. But if we could set the statute of limitations problems aside, the client could still go after Dahowski.
But that's not the purpose of the client security fund.
No, but
they want to
neither-
relieve the client of that obligation.
Well, I don't know that it was to relieve the client of that obligation, because one of the things that they were supposed to take into consideration in reimbursing clients was whether there were alternate sources of reimbursement, such as insurance. Now, there was insurance here. It could well be that the client security fund never should have paid off these clients. They should have said, or maybe they should have said, this is in their discretion, go ahead after the carrier for Mr. Dahowski. See, I think they extended their jurisdiction, their powers, way beyond what the legislature ever even thought about. If you read the debate that took place on this, nobody thought of anything like this. The idea of even going after the dishonest attorney was only an afterthought. And that was just brought in way at the end by, I think it was Senator Bernstein. It wasn't something that they contemplated. They certainly didn't contemplate using this recoupment of money from partners or lending institutions.
But on the basic premise or principle of the client security fund, it was to make the client whole again so the client could walk away from a bad experience, to redeem the good reputation of the bar, and the client would then be at peace with his or her money intact. Now, what you're saying is that what the client should do should be compelled not only to try to receive some money from the client security fund, but also to institute separate litigation in order to make himself or herself whole again?
Well, I'm saying that's kind of what we're left with the way the legislation was drafted. They just didn't include this. They only talked about going after the dishonest attorney. Now, the point that my opponent makes is that it should be read in by necessary implication. But this is not necessary to do this. It's not necessary to go after Dahowski. That could have been done by the clients originally. This is not a necessary implication. You can read into it by a tortured reasoning, and that, I believe, is what has been done.
Or by giving the statute what might be considered its broad intent.
But the broad intent was to not allow the crooked attorney to go free, to reimburse the people for the harm done by the crooked attorney.
And to let a partner who would have been co-liable to escape the net.
But his liability was only on the grounds of negligence. He was negligent. The appellate division found that he had no part in the stealing from the clients. He didn't know about it. He should have kept a better ledger book, maybe. He was a busy attorney like many of us, and he didn't. Now, that is not the function of the client security fund, to raise money by subrogation actions against third parties. It doesn't say that anywhere in it. It was given broad powers to determine the terms of reimbursement, the relationship between the client and the fund. It was given broad powers over.
Exactly what does the subrogation agreement say? I don't want you to read it all, but does it include an assignment of all causes of action?
Yes, Your Honor. Yes, it does.
All rights, claims, and judgments that claimant possesses against Grando, Dahowski, the law firm of Grando and Dahowski, their successors, and so forth.
Yes, yes. My opponent has taken the position that because they had the broad right to set the terms of reimbursement, and that included the right to have them execute these kind of agreements. But that's not the same as giving them the power to sue third parties on a claim that's not based on the dishonest conduct that brought about the claim.
If they're suing as assignee, then they're suing in the right of the defrauded party.
Yes, Your Honor.
So is the question really whether the defrauded party would have a cause of action against the partner?
Well, if we were dealing with a human being here, yes, but the fund is a creature of statute. It was created by the statute, and it's as if they only gave them a couple of limbs, not a full set of limbs. They didn't give the fund a full set of limbs to do what they're trying to do now. It's my position.
I guess my question is there a difference if we look at it as the fund, as the assignee of the defrauded party, suing in the right of the defrauded party, and if we look at it as the fund pursuing its own remedy under whatever rights the statute might give? Are there two different questions there?
If they have the authority to take the assignment, to set that as a condition of payment, then under ordinary subrogation law, they would stand in the shoes of the client. But my position is that the statute just doesn't give them that power to create that kind of an assignment, to make them, it's taking an assignment that the statute doesn't authorize, and then using that assignment as the authorization to go ahead and do what they want to do.
Well, I can understand the immunity from Dahowski being branded a dishonest lawyer under the major premise of the legislation. I'm having difficulty following your answer that there's some prohibition against the secondary or corollary or necessarily implied authority with respect to an assignment or subrogation agreement with the wrong party. Why is that, where is that forbidden?
Well, it isn't strictly forbidden in the statute. The statute doesn't address it at all. My point is that it depends where you start from. If you start from the idea that they can go ahead and do this because it's not expressly forbidden, well, then my opponent is correct. But if the statute is to be construed as only granting the powers that are expressed in the statute, plus those that are necessarily to be implied, then the power to do what they've done is not there. They don't have the power to do the things they want to do. It may be that these are good things, but that should be debated in the legislature. It isn't something they should go ahead and do, and then let's try and undo it later. It's something that if they have the power, there's no reason the legislature couldn't come right out and say, we give you the power to sue the partners.
Why haven't they? I mean, they've allowed the fund to be subrogated to the client's rights. The client has a right to sue the partners. Isn't it as simple as that?
It didn't say that. It didn't say that. All it says is they give them the right, the right to go after the dishonest partner, the one who did the stealing. It doesn't say anything about going after anybody else.
Well, they could do that anyway under the statute. Couldn't they?
Yes, they could.
Without any assignment.
Well, there would still have to be an assignment of the claim. There would have to be the technical paper passing in order to give them the cause of action to pursue.
But is there any reason of public policy or any statutory reason why this cause of action, this shows of action, which is really what we're talking about, that the defrauded person has, can't be assigned and sued on by the assignee and the right of the assignee?
Merely the statutory limitations upon the creature that is the client's
I don't
security
find
fund.
the statutory limitation you keep talking about. I see a provision in there that allows the fund to require a subrogation agreement from the client after paying the client. If it takes the client's rights, why can't it sue in the client's shoes against the partner?
There's no reference in the statute to suing anybody but the dishonest fellow.
No, but the statute allows them to take a subrogation from the client of all the client's rights. The client would have a right to sue the partner.
But the statute doesn't say all the client's rights. It says the rights against the dishonest attorney.
Well, that's the way you choose to construe it, but I'm not sure that I construe it the same way.
I see my time is up, Your Honor.
Thank you. Just in time. Ms. Harmon, what about the statute talks in terms of the Board of Trustees being able to settle this thing on such terms of reimbursement as shall require the claimant to execute instruments, take such action, enter into such agreements, with respect to claims against the attorney whose dishonest conduct resulted in the claim. Now here, I guess it's beyond dispute that this particular attorney, Mr. Dahowski, didn't do anything wrong. His act was one of omission, if anything. You have a clear wrongdoer here. You settle the claim, and then you execute releases, which release claims against Dahowski. Why couldn't he think, well, because I was innocent, I now walk home free?
Well, Your Honor, the first part of your question is why the second sentence of subdivision 6 doesn't limit the powers of the administrative agency here, the Board of Trustees that administers the Client Security Fund. It doesn't limit it because, number one, the including phrase is in the context, can only be read as one of illustration, not one of limitation. And I have cited numerous authorities to show that commonly the word including is not used to limit the broad word preceding the including phrase, but only to illustrate that word. Secondly, Your Honor, the entire second sentence of subdivision 6 really refers to the relationship between the Board of Trustees and the claimants. It in no way is intended to govern really the relationship between the trustees and the lawyers whose dishonest conduct resulted in the loss. In a nutshell, however, our case is that since there's no limitation in the statute, and since the Board of Trustees has been given the broad discretion to manage the fund, to set the terms and conditions of reimbursement, and to require the clients to execute such agreements as subrogation agreements, then any action by the Board of Trustees that reasonably furthers the statutory objective here, that is, the protection of the good name of the bar, must be sustained by this court.
Do you think the assignee, the board, can do more by virtue of the assignment than it could by proceeding under the statute alone? Does it have any greater rights by virtue of the assignment?
Well, the board's right is the board is explicitly given the power to enter into the agreements. One step further is to enforce the agreements. That is the only, to say that that's an additional power not included in the statute would make the statute meaningless insofar as it allows them to enter into the agreements.
Suppose the statute were to be construed as giving the authority only to pursue the defrauding person. Suppose that narrow construction were proper. But suppose the assignment had broader language and gave the board the right to pursue anybody, including the partner. What would control?
The assignment would control, in this case where the broad discretion has been given to the Board of Trustees, unless there were a specific limitation in the statute.
And you find none?
And we find none, that's correct. The chief asset of the fund in its ability to protect the good name of the bar is its ability to provide prompt, cost-free reimbursement to the clients who have been victimized by dishonest lawyers. Without that ability, the trustees of the fund would largely be prevented from accomplishing their statutory goal. If they're going to provide prompt, cost-free reimbursement to the clients, then they must have the ability to then, without requiring the clients to first pursue all their legal remedies in the court, then the fund must have the ability to pursue anybody responsible or liable under the law for those losses, or else two absurd consequences would occur. The first being, and it's almost shameful to suggest it, that it would absolve other lawyers and any other entity totally from their legal responsibilities. The legislature could not have contemplated such an absurd result that is contrary to public policy. Secondly, it would require unnecessary depletion of the funds and violate the fiduciary responsibilities of the Board of Trustees.
Ms. Hartman, it might not be a legal test that we could use, but do you think the legislature, as part of the legislative history that we're aware of in connection with this statute, would be surprised to find out that the purposes and effects of this statute reached other than dishonest lawyers?
No, Your Honor, I was just going to come to that point. My opponent suggested that there would be, from looking at the debates, there would be complete surprise. But if you look at the legislative history, including the bill memorandum, which is included in the record, it refers to the ABA model rules for client security funds. Rule 15 of the ABA model rules specifically refers to proceeding against not only the dishonest attorney, but any other attorneys, including his or her partners, who may be legally liable for the loss. Therefore, at least the drafters of the legislation, who were fully aware of all that went into the conception of the legislation, would not be surprised at that the fund is now pursuing subrogation rights against other than the dishonest attorney. And I also would point out that there are two cases cited in our brief, the New Jersey case and the Florida case, which illustrate how client security funds in other states, this is not a unique client security fund in the state, pursue other than the defalcating fund.
So you don't think there has to be an express authorization in the statute for the implementation arrangements between the fund and the defrauded clients to reach beyond what might be expressly authorized in the statute?
Could you ask that again, please?
Well, what I'm saying is if there's no direct authorization in the statute, and I think in answer to Judge Hancock, one of the points you raise is, you could then have the agreement, the subrogation agreement, extend beyond what the statute expressly authorized. I take it your argument is you don't need the express authority, as you see it, and I imply nothing as to where I come out on this, for the fund and for the defrauded client to exchange those kinds of legal relationships which will have an effect upon third parties, whether they are partners, a partnership, or others.
That's correct. They would, because the enabling legislation says that the trustees may require the clients to enter into such agreements and execute such instruments as the fund shall require, as the Board of Trustees shall require, and then the statute doesn't specifically say what the terms and conditions of those agreements are. Necessarily, there must be discretion with the Board of Trustees to establish the terms and conditions of those agreements. And indeed, the preceding sentence says they have the sole discretion to determine those terms and conditions.
You wouldn't take it one step further and say that they have authority to trace assets into persons beyond the partners and partnership, would you?
Yes, Your Honor, we do. In fact, there are numerous lawsuits right now commenced by the Client Security Fund against banks who have paid on forged instruments in violation of the UCC. So there's an example. Any right that the reimbursed client would have had, and that reimbursed client has assigned and subrogated to the fund would then have the right to pursue.
So the only outer limit would be some connection with the defrauded client.
It has to be a connection with the defrauded client, and it also has to be generally within the sphere of affecting the purpose of the statute, which is, number one, the fiduciary responsibility over the fund, and number two, to protect the good name of the bar.
I'm just looking at the complaint. I haven't studied it, but does it sue as assignee? I'd see paragraph 16 alleges solely by the reason of the foregoing negligence of the defendants, plaintiff has been damaged, and plaintiff is the fund, in the sum of $589,000.
Let me see.
I may, don't bother to read it.
Okay.
I just wonder if you can,
The,
you do sue in the right of the defrauded.
yes, in fact, the
party.
history of this litigation is that initially, Brandau and Dehowski declared bankruptcy, or Dehowski declared bankruptcy. In that proceeding, the Client Security Fund, presented a claim. then by stipulation, the parties allowed the client security fund to commence this litigation in the state courts against both Randall and Dehowski so that the state courts could determine whether there were rights, subrogation and assignment rights, and whether those were within the statutory powers. So it was the whole purpose of commencing the litigation. In short, Your Honor, we think that respondent is acting well within its statutory authority by pursuing its rights under the subrogation agreements against Mr. Dehowski. The unanimous decision of the Third Department is well-reasoned and correct. We suggest that the Third Department granted leave on a certified question to this court because the issue is one of statewide importance, and it wanted this court to cast its imprimatur on its decision. We ask this court to do so.
Thank you very much, Ms. Hartman. New York State Public Employees against the City of Albany.
Ready if you want, please.
Ms. Maney, in order to have uniformity in the state of New York under the Vehicle and Traffic Law, there's a specific provision which provides that no local authority shall enact or enforce any ordinance in conflict with the provisions of this chapter unless expressly authorized herein. Now, where is the express authorization, or where is it that you claim this express authorization exists for the establishment of these parking regulations?
Well, there are 3 sections which allow the City of Albany to enact a residential prepaid parking permit system. The first allows the city to prohibit, restrict, and limit parking, to provide for a prepaid parking permit system, and to enact additional ordinances with respect to traffic as local conditions require. And this court stated in Grant that exclusionary ordinances may be allowed where there's a reasonable basis in relation to the public convenience, safety, and necessity. However, there was a difference between the ordinance in Grant and the city's ordinance. In Grant, the municipality was preventing through traffic. In the city's ordinance, the city is not preventing through traffic. The city is maintaining through traffic by regulating parking.
Well, recognizing that distinction, though, Grant was very careful to point out with respect to residents that you couldn't distinguish between different classes. And in the 3 sections to which you refer, and I assume you're referring to 1640 A6, 15, and 16.
That's correct.
In none of those, is there any reference to giving residents priorities in parking areas? Again, remembering the expressly authorized section of 1604.
That's correct, but although uniformity is required, a municipality may make classifications. Classifications have been upheld by this court in Randazzo, where a 50-foot segment, a one-way street segment, was upheld to all vehicles except buses. And there, the court stated that when an ordinance limits through traffic, you have to weigh certain factors, and the appellate division in this case didn't weigh those factors at all. They said that you have to weigh the availability of alternate routes, any discriminatory effect, and the necessity for the regulation in relation to traffic conditions.
In other words, you draw no distinction between traffic conditions as such and parking provisions relating, such as these, to particular people being able to park or not being able to park.
That's correct, because the city is trying to maintain through traffic and to eliminate dangerous traffic conditions, congestion, and commuting.
Well, isn't that done by just limiting the amount of parking spaces?
No, because that wouldn't work to help the city get its goal of reducing commuting and congestion just by limiting spaces. The ordinance is geared toward vehicle use. If a resident leaves their car at home, they're not contributing to vehicle use. If a commuter parks away from their home, they're contributing to vehicle use and to the problems that the city is seeking to address. So the ordinance relates place of residence to vehicle use as a reasonable measure. In addition, other classifications have been upheld, such as official parking in a federal case and also in a case out of Rochester, and the reason there was to reduce congestion caused by illegally parked cars. In the White Plains automotive case, commercial vehicles over 27 feet were prohibited from traveling over residential streets where warranted by public safety. The appellate division ruling places...
Do you have any case where a classification between one kind of citizen and another? A
Any-
resident and a non-resident, or somebody who lives within a particular area and somebody who doesn't has been upheld?
Well, there's a case, I believe it's the Greenman case, where the vehicle and traffic law specifically provides for off-street parking or the regulating of parking lots by municipalities, and nowhere in there does it mention the word residence. However, the court in that case did uphold its distinction between residents and non-residents.
Well, we did in Randazzo.
Pardon me?
We drew a distinction in
That's
Randazzo between
correct.
residents and non-residents. Wrong
Right.
though we may have been.
Well, the court there, again, there was a reasonable relation with respect to public safety, which there hadn't been in the Grant case, and that was one of the distinctions between Grant and Randazzo. In addition, this ordinance is consistent with the vehicle and traffic law. It's not like the city is requiring plates on the sides of the vehicle instead of the front and the rear. Here, the basis of the city's ordinance and the basis of the vehicle and traffic law is one and the same. It's for the better protection and safety of the public at large. In conclusion, the city has the authority to enact such a system. Classifications are allowed. The city's ordinance benefits the general public and is based on a public safety necessity. Therefore, it's respectfully requested that the city's ordinance be upheld.
Thank you very much, Ms. Maney. Ms. Caldo?
Good afternoon, Your Honors.
What's so terrible about this?
We contend that the City of Albany has no statutory authority to establish an ordinance that grants preferential treatment to residents over non-residents. The reason that they don't is because of 1604, the Vehicle and Traffic Law. It's a uniform provision of the law, and it's been interpreted by this court in Grant.
Except there is an exception. They talk about 15, provide for the established operation, policing, and supervision of a prepaid parking permit system. And that subparagraph concludes, the provisions of this paragraph shall only be applicable for the City of Albany.
1648-15 has no statement in it regarding preferential treatment of residents. It does authorize the prepaid parking permit system of Albany, but it does no more than that. In order to override 1604, you need express statutory authority. This court noted in Grant that local authorities were authorized to make various types of ordinances, but that no local authority had the power to pass an ordinance that was inconsistent with 1604.
What about subsection 16? Let's assume that it would be possible to have a classification which could be upheld upon the ground that it was reasonable and that it served a legitimate state interest, relieving congestion and so on. Let's just assume that. Then would such a classification be permitted under 16?
No, I
Required
don't.
subject to limitations contained in the various laws of this state? Would
No.
it not, couldn't you argue that it would, if it's permissible as a classification, that it might be permissible under 16, the rather broad language there?
I don't believe so. The first, see, we argue statutory authority, so I don't think you get to, when you talk about distinctions in terms of classifications and whether they're reasonable, you're talking to me about reasonableness, and you're talking about constitutionality. And you don't reach that because the statutory authority is lacking. The 1640A16 specifically states that local governments can make additional reasonable laws, but they are subject to the limits contained in the law of New York. Section 1600 of the Vehicle and Traffic Law states that the traffic laws should be uniform throughout the state for all local governments. Section 1604 is a uniform provision that falls within the rubric of Section 1600, and that 1604 is supposed to also have uniform statewide application. So therefore, the city can't look to 1640A16 for its authority because it's pushed back to look at 1604. And if the ordinance violates 1604, then it's invalid. There's no authority. There's just no statutory authority for the ordinance. This court in People v. Grant noted in discussing
Well, that was so long ago. That was,
but it's still good law.
that's what you say.
That's what I said. This court in Grant noted the common law origins of 1604, and it said that the common law principle is that the fee of the streets is held in trust for the whole public, not just for adjacent property owners or specific residents, but for the public as a whole. Your Honors, a city resident who purchases a house with no garage or with no off-street parking does not acquire ownership rights in the adjacent streets, nor does a city, simply because the streets are running through it, get proprietary interests in those streets that it can then grant to residents. The proprietary interest in the streets is what the Albany ordinance does and what they're prohibited from doing under 1604. The city cited to some off-street parking cases, and I want to make a distinction between those and the situation here. Off-street parking in city-owned lots is different than, is a situation where the city is granting to residents rights that they have, proprietary rights they have in the city-owned lots. They're off-street. It's not public. It's not the public street. Grant specifically, not Grant, 1604 specifically in its language talks about the public street. It doesn't refer to city-owned lots. Therefore, if the city wanted to provide parking for residents in city-owned lots, it would not be in contravention of 1604, the Vehicle and Traffic Law.
Ms. Cordell, do you say that there is no interpretation or implementation of the prepaid parking exception authorization that would warrant this preferential treatment?
You're asking me whether there's anything...
In other words, is there a way to read the prepaid authorization exception that would be a reasonable implementation of that statute and that would support what the city is attempting to do here?
I do not believe so.
Why not?
Because the language of 1648-15, when you read it, there's simply no reference to granting preferential treatments to residents. You also, the legislature in its intent in establishing 1648-15 clearly shows that it was never intended to establish a residential system. All the memoranda in support of the legislation stated that it was meant to be a substitute for parking meters for the city of Albany, that it was to be an alternative for parking for short-term duration. And certainly, it's not been created to be a parking for short-term duration. It's essentially giving residents 24 hours worth of parking on the city streets as opposed to 90 minutes for everyone else.
So you say they're so different in kind that they cannot be a tongue-and-groove authorization and implementation?
It simply cannot do it. The city also cites to a number of cases in its brief and today, one including White Plains Automotive. I would like to point out to the court that most of the cases cited by the city were cases where the ordinance or whatever was enacted was challenged on equal protection grounds, that the statutory validity was not at issue, and that they don't have any relevance to the determination in this case regarding the validity of the Albany parking permit system, which grants preferential treatment to residents. Based on the foregoing, Your Honor, we respectfully request that you affirm the order of the Appellate Division, 3rd Department, which determined that the ordinance was invalid. Thank you.
Thank you very much, Mr. Cottle. Mr. Armstrong, let me follow up on Judge Bellicose's question. If the statute authorizes a prepaid parking plan, why wouldn't this be consistent with such a plan to allow certain people to prepay for the parking?
Oh, well, I believe that Section 15, by its express terms, Subdivision 15, does not talk about a residential permit parking system, just a prepaid parking system. It would go against the rest of Section 1604 and would be contrary to the legislative history of subdivision.
What if it said that any resident can park there on a prepaid basis, first come, first served?
That would be in contravention of Section 1604, which says that that no municipal law may be passed which would interfere with the free use of the highways. So it would be in violation of that statute.
But they do allow for prepaid parking.
Prepaid parking, but not prepaid parking for residents only. Again, we're
So if
talking...
they said anyone can prepay for parking, first come, first served, that's all right?
I would believe
It's
not.
not a trick question.
I would believe not, Your Honor. It seems to me that there has to be a reasonable use of the highways for...
What do they mean by prepaid parking? Permit.
I believe permit parking.
Well, who's to buy these permits? Pelicans? I mean, it certainly applies to
It would
either
be open to the
commercial
public.
and residential.
It would be open to the public, and I think there would be a question if it was challenged as to whether or not there would be sufficient permits available for the general public. If they limit it to, say, 50, I think that the ordinance could be declared to be unconstitutional, in violation of Section 16.
Well, what if they issued them for every space available?
Well, that one could work. It seems to me that you're dealing with a thin line where there cannot be an interference with the pre-use of the highways.
I see that 1604 was enacted in 1959, and I believe I'm right that both sections 15 and 16, paragraphs 15 and 16 of 1640 were enacted in 1974. Can it not be argued, and is there not some substance to the argument, that in 15 and 16, which refers specifically to Albany, and 16 seems to go along with 15, which is an Albany situation, that the legislature was carving out something special, and that if there was any inconsistency with 1604, it shouldn't apply to 15 and 16.
Well, Subdivision 15, which refers to the city of Albany, was sought to be amended a few years after its original enactment, so as to insert the words residential permit parking. That was never acted on, and it seems to me that's an indication that the statute Subdivision 15 never contemplated residential parking to begin with. Subdivision 16, I believe, says something to the effect that nothing herein can be passed which would be adverse or against any other laws that we have. I believe at the end of that section. So, in other words, I don't think that would enlarge anything.
You mean
Subdivision 16
16,
references, I believe, says nothing herein may be, no law may be passed herein which would be an enlargement of other
says rules and regulations with respect to traffic as local conditions may require, subject to the limitations contained in the various laws of this state.
Yes, Your Honor, I think that what I'm trying to rather fumblingly say here is that would reference us back to Section 1604, which says that you can't pass a law which would interfere with the free use of the highway. I think that limitation is contained in 16 by reference in those words that you used. Before I flee from here, I'd just like to reference that there's a very strong public policy here, and that is that if we allow the city of Albany to annex its own streets for parking, that would, by indirection, allow any other municipality to do the same. And if you're from out of town, it would be an awful long walk to the car. Thank you very much.
You're not rushing because you're parked illegally outside, are you?
Thank you. Matter of Industrial Liaison Committee versus Williams.
Ready to walk.
Mr. Hannah,
May it please the court if I could reserve 5 minutes for rebuttal.
if you find it necessary, certainly.
Environmental pollution requires strong medicine, and numerical ambient water quality standards are strong medicine. But before strong medicine is used, it's useful to consult with experts, identify side effects, and plan how you use and how you pay for it. And the issue here is how that is done. The DEC, the Department of Environmental Conservation, is granted by the court almost unlimited jurisdiction to almost unlimited deference on technical questions such as is 10 parts per billion the appropriate ambient water quality limit for a particular substance. The issue here is, does DEC also have almost unlimited deference to decide what the public will be told about the scientific bases for those numbers? How the DEC look for, find, and choose among the hundreds, if not thousands, of scientific studies that are relevant here? And how long is the public going to have to react to those scientific bases? Now, the State Administrative Procedure Act and the State Environmental Quality Review Act, which is what we're talking about here, are powerful policy statements of why government is doing something, what it is doing, and is it considering the relevant factors. They should be read broadly, those statutes. They're not just mechanical hoops. And they use strong, short words. In SAPA, the legislative finding is that the agency shall conform with sound standards developed in this state and nation since their founding through constitutional, state, and case law. That's pretty broad. Also goes on to saying that equitable practices will be provided to meet the public interest. The most precise provision in SAPA, that 30 days from notice to hearing, at least under the old statute, is expressed as at least 30 days. So a judgment is required as to how much is to be used. Other terms, public hearings on due notice, which is in the environmental conservation law, but is a mini SAPA, if you will, and preceded SAPA. Seeker speaks of agencies shall use all practical means, and the environmental impact statement shall include environmental impacts, including short and long-term effects. Now, DEC staff's failure here was not to respond to the substance of what's behind those statutes. Now, how does the court give meaning to words, broad terms like due notice and public hearings? Well, it's easy in this case because both the commissioner and the staff use the words. Their rhetoric really gives meaning to those terms. The problem is the words are right, but the actions didn't follow the words. The commissioner says, we have an obligation to make the latest technical information available so that the hearing process can elicit the best response from experts. And I might just insert here that the environmental conservation law, remember, says public hearings after due notice. The commissioner went on to say that he believed strongly in the value of public participation, so much so that he held 5 hearings, 5 public hearings. Nevertheless, the scientific bases expressed in documents as the fact sheets, but they were the scientific basis, which is what's important, were not supplied. Most of them were not supplied before the hearings at all, and those that were supplied just before the hearings.
Well, do you find, Mr. Hanna, any requirement for these scientific fact sheets?
I do, in the words,
Where do I find that in the statute?
due notice, public hearings after due notice. It's these broad terms that I just was describing.
But no specific requirement for scientific findings or fact sheets?
There's no statutory provision that says scientific bases must be provided. No,
And in
there is
fact,
not.
some were they not?
Some were provided before the hearings, but not long before the hearings, and most were not.
And do you claim that the hearings were a nullity, or were they meaningful with whatever amount of data was supplied and anything else that would have gone into them?
I think some things happened at the hearings, obviously, but they were not the kind of dialogue that the ECL, the mini SAPA, if you will, provided when it said public hearings after due notice. The federal court, for instance, in the Nova Scotia case, the Second Circuit comments that if it's based on a technical document and you don't have the technical document, that deprives the public of meaningful comment.
So while they might not have been a nullity, in your view, they would not comply with the statutory requirement?
Well, I think for statutory, I would say that they were a nullity for statutory purposes. People did come, people did make comments. Among the comments they made repeatedly was, we can't respond to what you've given us. You've given us 236 standards. That's an absolute mountain of things. For the kinds of, how we respond to this is we have to, you identify the document. That's all the fact sheet is. It's just an identification of documents that were used. You have to go find those. The computer's searches show digests. Once you identify the document, you get it sent to you, which could take 30 days by itself. And you read those, you study them, you analyze them, and compare them to the others. The scientific work of trying to deal with even any small portion of 136, with the fact sheets winging out kind of haphazardly and sporadically, is very daunting, and the commenters commented on that and protested repeatedly. Indeed, that whole process was what was so, the whole thing was so confusing and so difficult to deal with. When even the last fact sheets of those that did come, many never showed up at all, but when the last fact sheets came, many of those indicated standards that were different from the standards that had originally been proposed.
Is it a novel proposition under these circumstances for the courts to become involved to the point of prescribing the content of the hearings rather than the statute?
It certainly isn't. The federal courts have dealt with this more so actually than the New York courts have gotten into the rulemaking. And this indeed is really one of the very first of the really scientific environmental regulations, so that isn't too surprising that it hasn't come up before. The Connecticut power case really Judge McGowan really sets out the standard that the courts are certainly going to give deference to DEC. You're not going to tell them how to set a numerical limit, but you're going to make sure that they've told everybody what they're doing, what they're basing their decision on, and how they're getting there, what their rationale is. And that is what is really so important. There was a cloud of things they did, but it tended to obscure more than provide you a real basis for dealing with it. And that's why I say, in another case, this court might have to decide how much time is enough, how much should be in there, how much should be provided, but you don't have to do that here. The commissioner's done it for you. He says the latest technical information should be available. He had his own time limits. He said you should have it before the hearing.
What I'm trying to do is ascertain what our task is, because as I read the briefs, you have described the case as being quite monumental, perhaps not your words, but a major administrative law case. Your adversaries describe it as a rather 2x4, perhaps not their words either. Are we somewhere in between? Are we rewriting the requirements in connection with these kinds of hearings? I'm trying to discern what are you asking us to do?
What you're saying is that due notice means the things that the commissioner and his staff said. Not what they did, but what they said. What they said was the latest technical information should be available before the hearings. And I think the statute requires that, the ECL, due notice, hearings after due notice. And due notice here would be you have to have the scientific information before you can comment on it. The commissioner talked about 60 days. That's pretty brief under the circumstances, but he said 60 days. And they didn't provide you with any information before the hearing so that you could sit down, digest it, and come into the hearing, where he says the hearing process is important. That oral interchange is important. And indeed, it is important, because these regulations are mightily important. They certainly affect public health and aquatic life. They're one of a panoply of regulations, including drinking water and technological standards and all kinds of others. This isn't the only water quality kind of regulation out there.
Is there a provision for requesting an adjournment if, after you get
Among the
information?
commenters, they asked to have this postponed. They asked to put off everything. They asked for more time. This was a repeated theme through this whole thing, is give us more time. These are terribly
Always
complex.
denied.
Yes, for practical purposes. The commissioner didn't give as much time. What he said was, we're going to get the fact sheets out before the hearing, and then we'll have 60 days after the hearings for additional comment. That wasn't what was asked for, but that's what he gave. But that's not what happened either. And I can't understate the complexity of trying to deal with all of these, this vast array all by themselves. This vast array of technological and scientific data that had to be dealt
Could you have asked for more than 60 days?
As a matter of fact, some of the commenters asked for at least 90. They asked for more time that was not given.
Mr. Hanna, you've referred repeatedly to the complexity and confusion and all. I have a concern about the role of the guidelines in all of this. As I understand it, many of the standards carried forward what had been embodied in the guidelines, which had been in operation for several years before. Isn't that correct?
Several years. There are two answers to it. Well, basically the argument is that these regulations didn't do anything to the status quo, and therefore we can ignore SECRET, we can ignore the environmental impacts that were required under SAPA.
Or they didn't do anything really significant to the status quo.
Well, that's the basis for which they ignored both those requirements. Well, there are two problems with that line of argument on their part. First off, it's factually incorrect, and secondly, even if it was factually correct, it is offensive constitutionally and statutorily to important considerations, so that even if it was the status quo, it shouldn't be recognized. Firstly, on the factual issue, these TOGs, so-called, guidance series, are internal memoranda of the Division of Water. There are procedural memoranda. There are many of them. This was just one. And they came out, something like a year before these regulations were promulgated. No SAPA, no SECRET, no effort, no indeed deed from their point of view. The scientific basis for those TOGs, by the way, were never documented. That's in the record, clearly stated by very candidly by Mr. Pagano, that they were not documented before the regulations were promulgated. The ILC, petitioner here, among others, protested using TOGs in permits. And if you read the affidavit of the bureau chief in these papers, record 1010, it's very carefully worded, but it doesn't say they were using the TOGs and permits. It says they intended to, basically, is what he was saying.
I was about to ask, why then would the appropriate vehicle for challenging the guidelines not have been through a challenge to a permit?
That was basically the only way you could do it, would be in the context of a permit. Indeed, that's how the ILC challenge came up. It came up as a request for declaratory ruling during the course of a permit proceeding. The permit proceeding was adjourned, and ultimately the request for declaratory ruling was declared moot when these regulations came out. I mean, it was a little bit, you had the sense that somebody was playing a game. But the statutory purposes, obviously, and the constitutional purposes, is those were rules. They were fixed numbers that were going to go as a basis for any water quality limit in any permit. And it's clear in this state that those have got to be issued as rules. They have to be promulgated as rules. That's a constitutional and statutory provision. And to have the notion that you can run around and you can say, well, we'll use those for a little while, or even for a long while. That's not the case here, but even for a long while, and get around SAPA and seeker, I think is frankly obnoxious to the last 50 years' development of administrative law, taints the entire proceeding.
Thank you very much,
I see that I've
Kenny.
used up all my time, including the 5 minutes.
No, you haven't.
Oh.
You have 5 minutes left. Mr. Weinberg, this was to establish some degree of uniformity. What good does it do to do that and then allow these interpretations which would depart from the uniformity sought?
The purpose of taking the tugs, there were in fact 8 substances which were already the substances of regulation, but the purpose of taking the remaining 80-odd and making them regulations was indeed to provide uniformity and also to provide an ability on the part of the industry or anybody else interested to challenge a particular regulation. And of course,
but standards are codified from cases and so forth. And then after the codification, to allow the agency to interpret them seems to be self-defeating. Doesn't seem appropriate.
I'm not sure what Your Honor means by interpreting the standards. That isn't what happened here at all. What happened was that the TOGs existed, except for the 8 which already were codified as standards. The agency decided to get those others, which were only covered by the guidance documents, the so-called TOGs, into regulations so that they would be there in black and white. And of course, in so doing, they complied in every way with SAPA and seeker and adopted the regulations, which are the subject of the challenge here. Now the regulations, the standards which are now embodied in the regulations, ought to be used, as the TOGs indeed were before, in the particular permits that particular industrial or municipal or other sources of pollution of the state's surface waters have to get under the federal and state law. So that if one of the members of the ILC, an industrial polluter, in other words, applies, or any other, applies for a permit, his permit now embodies the consideration by the state in selecting the particular numbers in the permit, embodies the standards for water quality for these highly toxic chemicals that are now set forth in the regulation. So that, as was pointed out, the proper vehicle for challenging any of this isn't a challenge to a permit that's issued. If tomorrow one of the constituent members of the ILC, or indeed anyone else, gets issued a permit and says, well, this is unreasonable, clearly 10 parts per million is wrong, 8 parts per million or 12 parts is right, that's the point at which somebody can commence an Article 78 to challenge the particular numbers in the permit. Instead, we have here a broadside challenge to the adoption, which is kind of ironic, to the adoption of these standards in the first place, nearly all of which previously existed and to which the ILC and every other polluter in the state was subject.
Mr. Weinberg?
Yes, ma'am.
In the rulemaking process, what weight is to be accorded the guidelines? How does the fact that the guidelines were previously in existence lighten or increase the burden in terms of the rulemaking process?
Well, obviously the state had to comply with both SAPA and seeker. And incidentally, I'll be arguing the SAPA point. Mr. Keehan for the Attorney General's office will be arguing the seeker point, but we stand together with regard to these regulations.
Could the state seek any advantage in the rulemaking process out of the fact that the guidelines had previously been in existence?
Certainly, and that's precisely one of the points that I believe I tried to make in my brief and was about to talk about now. These appellants and everybody else who pollutes the waters and has a permit to do so were subject to the TOGs in any event. So that the same numbers, except for the variations, and the variations were very slight, nearly all of the 95 standards that were eventually adopted are exactly the same as the previous, the 8 regulations, or the remainder that were covered by the TOGs. A few were made more strict, And as to those, a regulatory impact statement was made. A few were actually loosened up because they found that the scientific evidence wasn't there.
But then isn't that a way around the Administrative Procedure Act?
No, not at all. It would be had the state decided to continue using the TUGs and maintaining the status quo ante, but that's exactly what the state did not do. The state, on the contrary, decided to put these into standards so that they would have to conform, as they did with both SAPA and SEEKR, and so that they'd be there in black and white for anybody to challenge.
Yes, but in the process, they relied on the fact that the guidelines had previously been in existence.
They could hardly not. Industry knew about it. The state obviously knew about it. They were using the guidelines, but that doesn't exempt them, nor should it, from compliance with SAPA and SEEKR. And contrary to the suggestion of the appellants, they did not disregard SAPA and SEEKR at all. We've heard a lot about the facts here. Of course, we're way past the point where the facts are at issue any longer. Both lower courts found that factually these regulations were reasonable, and that's beyond dispute anymore in this court. We've also heard allusions to the Constitution, which are interesting because there's nothing in any petition or even in the briefs about the Constitution. It's the first I've heard of that being advanced as an argument. Indeed, the standing of these appellants to raise any of the issues regarding SAPA, I believe, is highly questionable because they were raised by other petitioners who did not appeal, with the one exception of the RIS, the Regulatory Impact Statement. That was the only suggestion in the petition of these appellants that there was any impropriety at all asserted with regard to SAPA. In effect, they learned about the other arguments, which they now advance so vigorously, when they read them in the petition and the briefs of the other parties who elected not to appeal.
Isn't the fact that most of these regulations were in use as TOGs assigned as a reason for not having to comply strictly with the notice requirement of SAPA?
No, sir. This is what happened, actually, if I could explain that, because I think it's key to the understanding of the case. The TOGs were in force, as were the 8 original regulations. And of course, the appellants all had permits, so they knew very well what substances they were discharging. There's no question about that. The state, in its original notice of hearing, which happened back in September, when it supplied the draft EIS and the remaining documents, told the appellants, and indeed everybody else, precisely what the methodologies were to be. They had the methodologies, in other words, the scientific explanations for how these numbers were going to be arrived at. They knew themselves what they were discharging, and they also knew that they were subject to the TOGs. The TOGs were not enacted or enforced in a vacuum. There was a work group which included those industrial groups as well as environmental groups